The defense attorney asks you during your medical malpractice deposition what doctors you are treating with, what doctors you have seen. If you fail to tell that attorney about a doctor you are recently seeing, can you bring that doctor in to testify at the time of trial? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is no, you can't do that. If you intend on bringing a particular doctor into court to testify on your behalf, the whole point of doing that is to let the jury know exactly what the doctor did, to let the jury know exactly what the doctor's examination consisted of, to let the jury know what their findings were and what problems you have now, as well as what treatment you're going to need into the future. So now, if you have that information, why would you ever conceal that? Why would you ever prevent the defense from learning about that information? Some people may say, well, my medical condition is private. I don't want to share that information with anybody. Well, guess what? When you bring a lawsuit seeking money as a form of compensation for all of the harms and losses and damages that you incurred because of someone's carelessness, whether it's a careless doctor, whether it's a careless driver, a careless property owner, you put your medical condition in issue, which means the defense is entitled to learn everything about your medical condition. And now you are claiming that your injuries are preventing you from doing your daily activities. They are limiting you from doing everything that you used to be able to do. Now, how does the defense attorney actually learn this information? Well, they learn it by obtaining your medical records. They learn it by questioning you during a pretrial question and answer session known as a deposition. If you actively choose not to tell the defense attorney about a particular doctor you are seeing, when your case ultimately goes to trial, your attorney will not be able to bring in that doctor to testify. Why not? It's because now this attorney is going to claim, the defense attorney is going to claim that he is prejudiced. And you know what? He'd be right, because this is the first time at trial that he's now learning about this doctor whom you have seen. Presumably, you're bringing in this doctor to testify that your injuries are significant or permanent. And guess what? This guy has no idea who this doctor is. He doesn't know what treatment you've received from him. He doesn't know anything about his opinions. He knows nothing. And now if you try to bring in this doctor to testify on your behalf, the defense attorney is going to claim prejudice. And in all likelihood, the judge is going to agree and not allow you to bring this doctor in to testify. The proper thing to do is to have your attorney provide permission slips so that the defense lawyer can go ahead and get copies of the medical records from this particular doctor, your medical record. And then, now the defense attorney can ask you questions about what problems you had and what this doctor did and did not do, as well as what treatment he's contemplating into the future. Now that you've shared all that information with the defense attorney and provided records so he can obtain them, guess what? If your case goes all the way to trial, now your attorney can bring that doctor in to testify without a problem. So why do I share this information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.